Hi everybody, my name is Aaron and welcome back to my channel. A ruling just came down this week from a California appeals court that should have David Miscavige shaking in his size 7 boots. The ruling has to do with the enforceability of Scientology's internal arbitration agreements. And this ruling is the first defeat that Scientology has seen in court about these agreements after a winning streak that goes back about 6 years. The reporting on this ruling has been done primarily at Tony Ortega's blog. For this video, I'll be quoting and excerpting and paraphrasing from that reporting. Now, I'm going to talk for a few minutes about the Scientology arbitration agreements themselves, and then I'm going to discuss the actual ruling. If you would like to jump forward to the part in the video where I discuss the ruling, I'll put a timestamp right here that you can jump to. I'm also going to have chapters labeled on this video for your convenience. The ruling that came down this week is related to the civil lawsuit that has been brought by the victims of Danny Masterson. This civil lawsuit is peripherally related to the criminal lawsuit that has been brought against Danny Masterson by the district attorney in Los Angeles for drugging and attacking women. So these internal arbitration agreements that this ruling was about, these agreements are one of the main reasons, if not the main reason, why you see so few civil cases brought against Scientology and even fewer cases, if any at all, actually won against Scientology. Scientology has all of its members sign these unbelievably comprehensive internal arbitration agreements before any members are permitted to do major courses or major auditing in Scientology. When you first get into Scientology, the first thing they have you do are these very cheap, very short courses about common sense life things like communication, relationships, problem solving, organizing, time management, things like this. These courses, these services as they call them, these things are designed to give you the impression that Scientology is just a common sense, feel good, self-help kind of thing. It's all designed to feel very unchurchy, unreligion-y, very non-threatening, non-invasive. It's all designed to very much not impinge upon or conflict with any beliefs you might already have. Scientology will let you sign up for these introductory services without looking too much into your history, your personal connections, your familial connections, without getting too much into your business, and without requiring you to sign a great deal of paperwork. The fact that Scientology hasn't really looked into you yet, and they're not really quite sure about you yet, is why these introductory services are actually done in a separate part of the building that is intentionally kept completely removed from the rest of the building where real Scientology is going on. Scientology's strategy with these introductory courses is to let you keep doing them until you start showing interest for doing the actual bridge, or what Scientologists would consider real Scientology services. So once a new introductory member starts showing some interest in doing major services or, real Scientology, the registrar is ready to sell this person some major services. This is where you're talking about courses that take weeks or months, that cost at least $2,000. And another aspect of these major services is you are not permitted to start them without going through the Scientology gauntlet, having your background and connections and personal relationships very carefully examined, and most relevant to the issue we're talking about today, you have to sign a boatload of paperwork. You are not permitted to have the paperwork reviewed by an attorney. You are barely given time to read the paperwork itself, and this paperwork includes what is called the Scientology Service Agreement, and the Scientology Service Agreement includes what is the Internal Arbitration Agreement Clause. All of this paperwork is, of course, designed to protect Scientology and its interests, particularly its legal and financial interests. You sign away all of your rights to any of the information ever collected about you by the organization. And you also sign away your right to ever sue another Scientologist or to sue Scientology for any reason. And not coincidentally, once you have moved over to doing major services and are considered at this point a real Scientologist, this is also right around the time when Scientology starts being not quite as nice. In the introductory services area of the organization, everybody is super nice, super permissive, very flexible, willing to work with you on your schedule. You're treated like a very important person and like you are very smart and wise for having found Scientology. Once you get over to the major services part of the organization, the tone tends to change markedly. The more major services that you do, the more courses and auditing that you've done, the less flexible and willing Scientology is to put up with your BS or any of the reasons you might have for not being completely willing and able to march precisely to the beat of Scientology's drum. It becomes much more, you're going to do as we say or else. So I didn't want to spend too much time talking about all that, but that does give you an idea of how, when, and why these internal arbitration agreements come into play and how Scientology uses them. Scientology hasn't actually always had these service agreements, these arbitration agreements. This is something that came into play certainly more in the era after Miscavige took over control of Scientology. But even more specifically, I believe it was more in the era after Scientology regained its tax-exempt status in 1993. The church's attorneys basically examined how all these cases were able to be won against Scientology prior to the 1993 era. And it was adjudicated that if members were to sign these arbitration agreements, it would be next to impossible for the lawsuits that Scientology was faced with prior to 1993 for them to continue to have to face such suits after 1993. Okay, so now let's get back to the ruling in the Danny Masterson civil case. Danny Masterson's victims, the ones who were Scientologists, those victims were abused by Danny when they were still in Scientology. Technically speaking, legally speaking, particularly if we're describing this from Scientology's perspective, the internal arbitration clauses in the service agreements that Danny's victims signed as Scientologists would legally prevent any of them from bringing a civil case against Danny for any of the things that happened while they were Scientologists. But the civil suit that Danny's victims have brought is not relating to the attacks themselves. The civil suit is regarding the harassment Danny's victims have experienced since filing the police reports with the LAPD in 2016. The civil lawsuit was filed in 2019. From 2016, when the victims filed their complaints with the LAPD, for the next 3 years, the victims have all experienced some form of harassment from Danny Masterson and people associated with Danny Masterson. Those are the allegations. And yet, despite those facts, in December 2020, an LA Superior Court judge, Judge Kleifeld, ruled that even though the victims were alleging abuse and harm that occurred during a period after which the victims had left Scientology, the judge ruled that the victims were going to be denied any ability to bring this matter before a court of law, and that they were going to have to submit themselves to Scientology's internal arbitration process. After Judge Kleifeld issued his decision, the plaintiffs then petitioned the California Supreme Court to order the appeals court to intervene. The Supreme Court granted that request. So then the appeals court, the same appeals court that had already refused to intervene in the Judge Kleifeld decision, that appeals court, it's a 3-judge panel. They reviewed Judge Kleifeld's decision. This week, they issued an order overturning Judge Kleifeld's decision and sending the matter back to his court for review. That is the ruling that came down just this week. In fact, just 2 days ago, this past Wednesday. Now, this might seem like a minor victory in the grand scheme of things, but when you look at the overall context of how Scientology has tried to enforce these agreements, and when you look at the arguments Scientology's lawyers have made in court about how broad they believe these agreements to be, or more specifically, how broad they believe their ability to enforce these agreements are, this ruling that has come down is actually quite an important one. To give you an idea of just how broad Scientology and their attorneys believe the enforceability of these agreements are, let me read you this excerpt from the reporting that Tony did on this. He says here, "Looking back, it struck us as a particularly bizarre moment during the November hearing when one of the justices had asked Scientology's attorney, William Foreman, if someone took a Scientology course and signed a service contract, and then 20 years later was run over on the street by a Scientology van, would they be obliged to take that dispute to religious arbitration?" Yes, Foreman had responded, and it sounded as ridiculous then as it does now. So to sum it all up, what we have is the first ruling ever that a Scientologist who signed one of these internal arbitration agreements cannot be bound to that agreement after they leave Scientology if the complaint has to do with a Scientologist's behavior after this person left Scientology. To some, it may seem like a small decision in an individual case, but it's actually quite an important decision, and the first time such a decision has been made. So that's what happened this week, and I wanted to share that information with all of you guys. Another thing I want to share with all of you, for my viewers in the United States, on Thursday, February 3rd, we will be hosting a virtual fundraising event with Leah Remini and Mike Rinder and other special guests. This is a fundraising event for my campaign for Clearwater City Council. The campaign event is limited to those in the United States due to campaign finance laws. The event will be held over Zoom. I will put the details of the event and the link for where you can purchase tickets in the description down below. Thank you, everyone. A big thank you to all of you who do watch until the end of my videos, and I'll talk to you guys soon. Bye.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe